Bonjour. Il s'agit du meeting numéro 2.
I call this meeting number 2 of the Legislative Committee on Bill C27 to order.
Reference of Thursday, April 5th, 2007. Bill C27, an act to amend the criminal code, dangerous offenders and recognizance to keep the peace. Appearing in front of us now, we have the pleasure to have the Honorable Rob Nicholson, Minister of Justice and Attorney General of Canada, and also from the Department of Justice, Senior Officials, Mr. Doug Hoover. Welcome, both of you. Mr. Nicholson, please have your introduction remarks.
Thank you very much, Mr. Chairman. I'm pleased to be here with Mr. Doug Hoover from Justice Canada, and he has been looking at this piece of legislation and this particular area of law for quite some time, and is an expert in the area, and I'm pleased to have him join me today. Pleased to get the opportunity to come before this legislative committee to talk about some of the significant reforms to the criminal code, in particular to sections 810.1 and 810.2, the peace bonds, and to part 24 of the criminal code dealing with dangerous offender provisions. Now, this bill was tabled last October as a response to the concerns of Canadians and all provincial and territorial governments that the existing provisions of the criminal code that target the most dangerous and high-risk offenders in the country required some changes to respond to the emerging issues in the courts. The government had indicated previously that it was committed to reforms in this specific area, as we believe that repeat predators sometimes escape dangerous offender designations and are then released into the community without adequate supervision and management. This bill tackles the problem by giving prosecutors the tools they need to achieve dangerous offender designations against offenders who clearly present a threat of serious injury to the general public. It also toughens the peace bond provisions in the criminal code that allow attorneys general to place strict conditions on individuals released into the community, often after serving their full sentence, even though they are clearly a high risk to reoffend violently or sexually. I wish to emphasize that these reforms were in large part based on ongoing consultations with our criminal justice partners in the provinces and territories. Most of these measures were in fact the subject of extensive review and recommendations by senior justice officials from every jurisdiction in Canada. At the same time, we have taken every step to ensure the constitutional rights of individuals have been protected. In my view, this bill achieves a proper balance between the rights of Canadians to be safe from violent and sexual offenders and the fundamental rights of an accused facing a lengthy prison term. As I indicated, C27 focuses on reforms in two areas of the criminal code, which I would like to explain in greater detail. First, this bill introduces a number of important amendments to sections 810.1 and 810.2 peace bond provisions that impose conditions on high-risk sexual and violent predators released into the community. The maximum duration of these conditions will be doubled from 12 to 24 months. This reform will allow police to avoid having to return to the courts to renew a peace bond in the appropriate circumstances. This will give police and justice workers a much greater degree of flexibility in the long-term ability to monitor and supervise these individuals. The bill further enhances society's ability to control these individuals under a peace bond by making it clear that a court has the ability to consider and impose any reasonable conditions necessary in the circumstances to ensure the safety of the general public from future harm. The bill also stipulates that a number of specific types of conditions are available and that in the past many courts have refused to consider. These include electronic monitoring, medical or psychiatric treatment, residency conditions, and drug or alcohol prohibitions. These new provisions respond to a number of recent court cases that have had the effect of limiting the range of conditions under the current wording of sections 810.1 and section 810.2. C27 will therefore improve the way we manage the risk to the general public posed by individuals in the community. Now, the second major area of reform that Bill C27 targets is individuals who are at the highest risk to offend sexually or violently, to ensure that they are not released into the community unless and until they can demonstrate that they no longer pose a threat to public safety. The bill accomplishes this by giving Crown prosecutors the tools they need to secure dangerous offender designations against these individuals, which result in an indeterminate sentence of imprisonment with no opportunity for parole for 7 years. The reforms also encourage Crown prosecutors to be more vigilant in using the dangerous offender sentencing option. C27 accomplishes these objections through 4 significant amendments to the dangerous offender provisions in Part 29 of the Criminal Code. First, Crown prosecutors will be required to consider and declare in open court whether they intend to bring a dangerous offender designation whenever an individual has been convicted of a third prerequisite violent or sexual offense. This amendment ensures that the dangerous offender provisions will be used more consistently in all jurisdictions. I note that since the bill was tabled, some provinces have expressed concern that this amendment would fetter prosecutorial discretion in sentencing decisions. So, therefore, I wish to emphasize that this amendment does not force a provincial prosecutor to make the actual dangerous offender application. It requires only that the Crown consider and indicate to the court whether they have considered the dangerous offender option. If the reform went so far as to make the hearing automatic, in such cases, the provinces would have a very strong case that the bill intrudes on their traditional and important discretion to seek appropriate sentences. Second, Section 753 is amended so that any offender convicted for a third time of a short list of serious, violent, or sexual offenses will be presumed to fully meet the dangerous offender criteria. The onus will then shift to the offender to rebut that presumption. This change will make it easier for Crown prosecutors to obtain dangerous offender designations in the very worst cases of violent and sexual misconduct. I believe that this provision will withstand any constitutional change, as the presumption does not go to the issue of presumed innocence, given that this offender has already been found guilty. The Canadian Charter of Rights and Freedoms protection regarding the right to be presumed innocent, while it is a basic right entrenched in Section 11D, does not extend to the offender once found guilty. And this view is consistent with the Supreme Court of Canada decision in Regina versus Lyons, where the court held that the right for a trial by jury does not extend to a dangerous offender hearing, as again, the individual subject to the dangerous offender application has already been found guilty. Third, Section 753 is amended to codify the need for the sentencing judge in every dangerous offender hearing to consider whether or not there is a lesser sentence available that can adequately protect the public. This amendment is required to properly respond to the landmark constitutional decision of the Supreme Court of Canada in the case of Regina versus Johnson. As it currently stands, there are varying interpretations of that decision being applied in different jurisdictions, resulting in confusion and uncertainty, and what amounts to a handicap against Crown's attorney in some provinces in dangerous offender hearings. This amendment will ensure that prosecutors in all jurisdictions are not necessarily handicapped due to varying interpretations of the principles in Regina versus Johnson. And consistent with that decision, this amendment will stipulate that when applying the requirement to consider whether a lesser sentence can protect the public, the burden is in fact not on either the Crown or the offender. Finally, the bill introduces 2 amendments to Section 752.1 to provide procedural relief regarding the filing of Part 24 psychiatric assessments. These amendments are intended to respond to specific concerns that forensic psychiatric resources in many jurisdictions are often stretched thin by the requirements of dangerous offender hearings. So by extending the time periods for the filing of the mandatory psychiatric assessment under Section 752.1, Crowns will be better able to meet the prosecutorial requirements of a dangerous offender application. Before I conclude, Mr. Chairman, I would like to address concerns that have risen recently in regard to this bill. I'm aware that a number of jurisdictions have requested an amendment to allow for a dangerous offender rehearing where an individual who has been found to meet the dangerous offender criteria but was sentenced as a long-term offender breaches a condition of the supervision order. I would note that on this issue, my officials are currently engaged in consultations with senior officials from all provinces and territories to identify a viable and constitutional methodology that can be supported by all attorneys general across Canada. So while I'm supportive of that process, I am aware that there are a number of concerns that must be considered, not the least of which are some serious constitutional issues, such as the potential Section 11H Charter challenges regarding the right not to be punished twice for the same offence. Having said that, it is imperative that we continue to move forward with Bill C27 while we continue to develop options to address the new and emerging views of the provinces and territories. In closing, I wish to thank honourable members for allowing me the opportunity to come before you today, and I would be pleased to respond to any questions that you may have as time permits.
Merci beaucoup, Monsieur le Ministre. Now we'll start.
Thank you very much, Minister.
7 minutes round, and we'll start with Mrs. Jennings, please.
Merci, Monsieur le Président, et merci, Monsieur le Ministre, pour la présentation.
Thank you very much, Minister, for your presentation. We on the Liberal side have some concerns about this bill, specifically with respect to reverse onus provisions, which you've included in Bill C27. At this point, it is usually the Crown that bears the onus of proof. When the time comes to designate a person a dangerous offender, then the onus falls on the Crown. In your case, it would be the offender who would have been found guilty 3 times of these offenses, who would bear that burden. I wonder if the test of proportionality was applied under Section 1 of the Charter. That's my first question. If this bill were to be passed and there were to be a challenge on that point of the reverse onus provisions, and the courts were to find that the appeal has merit, would that jeopardize the entire system, or in part jeopardize the system with respect to dangerous offenders? So that's the second question. Third point, I would like to know why the breach of a supervision order of long-term offenders in actual fact, a large number of long-term offenders have already had a hearing for dangerous offender hearing, and the Crown has brought prima facie evidence, and the judge, based on case law, must see whether the risk and the threat posed by the individual, in fact, if the individual could be controlled in the community through supervision orders, etc. So we, the Liberals, are very much tempted to bring forth an amendment to make sure that this type of breach be made part of those cases where the Crown could have a dangerous offender hearing. How much time do I have? Inaudible?
Mr. Chairman, thank you, Madam Jennings, for that. Of course, we looked very carefully at the constitutionality of all the provisions of Bill C27. As I indicated in my opening remarks with respect to the change of presumption, it's very narrow in the sense that it's only at that third conviction. It's after the individual has already been found guilty, and as I indicated to you, the indications that we have from the Supreme Court of Canada that, among other charter protections, the presumption of innocence is not offended at the sentencing stage. And so I'm confident that having a look at this and changing the onus as to who has to prove what at the dangerous offenders application is narrowly drawn enough from a narrow group of offenses that it would withstand that scrutiny. You indicated that if there was a problem with that with other sections of the dangerous offenders, I mean, it seems to me this is a refinement of that. And again, we not only had a look at that in terms of its constitutionality, but we codified the provisions and the remarks of the directions of the Supreme Court of Canada in the R.V. Johnson case. So I'm prepared to believe, and in terms of the advice that I have received, that this will withstand a constitutional challenge. You indicated as well in your comments as to why we don't bring an amendment with respect to those out on long-term offender designations who have breached the terms on their release. And I guess fairly briefly indicated to you that there may be some constitutional issues, but more importantly, I mean, of course, that's very important anytime there are constitutional issues, but in addition to that, this is the subject of a number of discussions between the Federal Department of Justice and our provincial counterparts. And so while I'm very sympathetic to making sure that individuals who don't live up to their court-ordered sanctions are meted out with the proper response, rather than go ahead with an amendment at this time, I would ask you to withhold that. Let's get this part of it through, and we'll continue to follow up in the other area.
Of breach of a long-term offender supervision order. I've had discussions with Crown prosecutors. I've also had discussions with attorney generals. And I know that there's a letter that's been sent to the chair of this committee indicating that the Ontario Attorney General and the Saskatchewan Attorney General, and apparently there are other provincial Attorney Generals who seem to be coming on board in favor of the Liberal proposal that a breach of a long-term offender supervision order be included in the offences which may trigger a dangerous offender hearing. And in fact, you would probably be in the best position to tell this committee how many long-term offenders were designated long-term offenders as a result of a dangerous offender hearing.
Could you look that up? We do have that information. We have an information on a number of those, but on the first part of that, Madam Jennings, one of the provinces I know that I think you included, the province of Saskatchewan actually wants the discussions between the federal and provincial and territorial justice departments to conclude. So I would ask you to wait till that is concluded. I believe that's what they want, or most of them want, at this particular time. But again, you're aware of this government's justice legislation. We're very sympathetic to strengthening and clarifying the provisions of the criminal code, and so I would suggest to you that you hold that for another day and let's get this bill passed, because this, I'm sure, will be very welcomed. Could you shed some light on that?
On the specific issue of long-term offenders who meet the dangerous offender criteria, it's really not possible to give a definitive number because you'd have to actually look at the reasons for the actual designation. Certainly, I've taken a hard look at all the cases that have come down post-Johnson, and sometimes the judge is quite explicit. He will say that I've considered, that I find that you meet the dangerous offender criteria, but you don't meet the Johnson test, therefore you can be managed successfully and you are an LTO. And other times the judges aren't very specific as to the rationale. So it's difficult to place a really strong number, but I can perhaps suggest that when we look at a number of the appellate decisions post-Johnson, there's been about 40 appeal cases brought by dangerous offenders, designated dangerous offenders on the strength of a Johnson-type argument. About half of those have resulted in an order for a rehearing or the lesser sentence. So that kind of tells us again that there's a significant number out there. That's a telltale sign, I guess, that there's a significant number that are of long-term offenders that are in fact meeting the dangerous offender criteria. But as far as specific numbers, we have not done a study to analyze all of the judgments. And again, I don't know that such a study would give you an empirically valid number. So it's difficult to really respond to that.
Monsieur Ménard, s'il vous plaît.
Alors,
Mr. Minal. Welcome, Minister. Welcome to both of you. You know that in the past we've cooperated with you a great deal. In fact, you're blessed by the gods to the extent to which the opposition has supported you. But unfortunately, with respect to this bill, I don't know. It seems reasonable in some respects, but this bill seems excessive to me. I'd like to know what you're trying to address here. Is it possible that under the current provisions, after a first serious offense, a person could be considered a dangerous offender? So your bill is arbitrary in nature and biased, and we have a hard time understanding the rationale behind it from a legal standpoint. So what are you trying to address here, first of all, and what is not working within the dangerous offender system, because that's what we're addressing here, and why a list of 12 offenses for which we don't really understand that relationship? Why would you have focused on those offenses when there are other offenses that are just as serious, relating to child pornography, impaired driving, causing death, robbery, etc.? They are not part of that list. So as legislators, what are we trying to deal with through this bill? What is not working in the current regime that we have for dangerous offenders, and why a list of 12 offenses? And try to be brief because I have two other small questions for you. Minister.
Very much, and I hope I continue to be blessed by the gods in your turn, Mr. Menard. You asked about the rationale, particularly on this. There are a number of provisions. One of them are with respect to peace bonds, and we've had basically universal agreement that moving it from 12 to 24 months actually would be of some assistance in terms of dealing with some of those individuals. In addition, we are trying to address the Supreme Court of Canada decision and the Regina versus Johnson decision. We've had actually a decline in the number of successful applications, in some cases even attempts to designate an individual a dangerous offender. It added some uncertainty to the process, and there has been uneven interpretation across the country, so we are trying to standardize that. In addition, you asked what would be the rationale between some of these offenses. In the study by Mr. Hoover and others, these were the ones that were most often the subject of those dangerous offender applications. And so, yes, we are zeroing in on the ones that have been found to be dangerous offenders. And part of what we are trying to do is to make sure that through inadvertence or oversight, we are not missing the opportunity to have someone. So That's why we asked the Crown to direct their attention
Mais
to
qu'est-ce
this.
qui va pas?
Sir, go ahead.
All right, but what is lacking or what is not working? The designation of dangerous offender was something that we would want to have operational within the criminal code. Based on the statistics from the Library of Parliament, we're talking about 334 people, 24 cases a year. Explain to us then, what are the difficulties you've experienced in terms of actually making the existing provisions effective, and would it not be preferable to focus on, well, listen, if you're going to bring a bill forward to enhance the dangerous offender legislation, I'd be really surprised if my party were not to support it. But this idea of 3 strikes you're out is just unreasonable to me. Why engage in this kind of process, which is American inspired, and what exactly is not working with the regime as it stands?
Agree on your characterization that this is similar to, I think you indicated American law, whereby you get 3 convictions and you're automatically given a particular sentence. This is very much unlike that. These, all we are saying at that third, when that third offense has been committed, that the presumption shifts to the individual to show why he or she should not be a designated offender. That presumption can be met, and ultimately it's at the discretion of the judge as to whether that designation or a lesser one. So to that extent, it makes it very, very different in my opinion. And so
Le régime, là. Expliquez-nous concrètement.
But in actual fact, what is the problem with this scheme today?
Menard, it's our job to clarify the law and to make sure that that this particular proceeding is actually considered. That's why we have the Crown Attorney to indicate to the court whether he or she will consider it, and then it seems to me only reasonable at that time that the presumption go to that individual. These are long, very difficult, expensive cases. To have one of these, they use up a great deal of resources, and in terms of
Mais il y a une difficulté. Donc, il y a une difficulté que les...
There's a problem then with the Crown prosecutors. What I'd like to understand then is what is not working in the system. Perhaps we need to make some amendments, but is it because the prosecutors, the Crown, are not using certain provisions? Is it too complex? What is not working today with the dangerous offender system today?
On a procedural issue, there, especially post-Johnson, we heard a number of Crowns in our consultations suggest that a new strategy used by defense counsel in dangerous offender proceedings was beginning to manifest itself. Specifically, if the offender chose not to participate actively in the psychiatric assessment, it became, because the burden of proof is beyond a reasonable doubt for the criterious portion of the hearing, it became exceedingly difficult to prove based on the offender's actual condition today, and what they would have to do is result in more forensic type analysis of his past records, especially if the offender was either by desire or incapability to participate actively in the prior studies as well. It was actually, in some cases perhaps, close to impossible to achieve the objective of beyond reasonable doubt. So the presumption will definitely help, because it will start off, it will draw out the offender in that situation. They will have to come forward and make their case. They will not be able to go mute. They will not be able to stop participating. And certainly, again, because of the narrowness, the scope of the offenses, this is carefully tailored to target those offenders who clearly, on the surface, on the face of the facts, would fit ab initio, that definition of a dangerous offender.
Est-ce que j'ai encore un peu de temps?
Merci. Monsieur,
Do I still have some time? No, thank you. No, Mr. Comartin, please.
Merci, Monsieur le Président. Thank you
Thank you, Mr. Chair.
for being here. I guess to some degree I want to follow up on Mr. Menard as to why we're using the reverse onus in these circumstances, and I guess I'm looking for some numbers. Mr. Minister, this is information I've got from your department. In terms of how many are being designated at this point, and that from the time we started using the dangerous offender designation, there's been a total of 384 designations. That's going all the way back to 1978. That in fact, the number that are being designated on an annual basis is increasing now. In the early years it was only 8, and now it's running about 17 to 18 a year. In that regard, your department wasn't, when I requested it before, I don't know if this is available, but my question is, again following up on Mr. Menard's, what problem are we trying to resolve? So how many cases do we have on an annual basis, if you can give me this, where this would apply, where there would be a third offense and the individual, after the assessment, would be required to prove why he, and I'm saying he advisedly because there have been no women designated as dangerous offenders as far as I know, why he would have to prove it. And so I'm asking, is there in fact a problem? And I want to add to that, I have a perception from the experiences I've had and noted in the criminal justice system that by and large, most of the offenders that we're going after usually we're going after when it's a serial killer, a serial rapist, somebody who's committed a series of crimes, and we're going after them the very first time. We're not waiting for the third time. And so I'm just back to, do we in fact have many cases where this is going to be used?
In response to your question, Mr. Comartin, we expect to be about 50 cases would fall into the category that I described to you on the third.
Per year?
They're 50 cases per year, and you're quite correct. The Crown can apply for a dangerous offender designation on the first conviction. There's nothing stopping them. But I guess we're making the point that, and this comes to our attention from time to time, individuals who repeatedly commit some of these very serious sexual and violent crimes. People ask, well, what's the problem? Well, Mr. Hoover indicated you some of the challenges that have crept into the system and that are presenting challenges. And in terms of your question to me, I think it's only reasonable. If you've been convicted twice and now for the third, these are convictions, people of serious sexual violent crimes, it seems to me that what we are asking to do is only reasonable. Could you please tell us why you shouldn't be designated a dangerous offender? I think it's a reasonable question to ask. And in terms of the presumption, that individual is guilty. We're talking about somebody who has done it. And again, I think the public has a right to ask and to require these individuals, if you're not going to get that type of a sentence, then you should come forward and say why. Again, as I indicated to Monsieur Menard, ultimately the judge has the discretion to give whatever sentence that he believes appropriate, and in that case it doesn't have to be the dangerous offender. So that part of the system is preserved and it's still part of it, but again, I think what we're suggesting here is just reasonable. Did you have anything to add on that, Mr. Hoover? Okay, sorry.
But Mr. Nicholson, you know as well as I do that if you're sitting there as a judge, and again I want to just point out these figures from yourself, of those 384 that went in, I think it's a very small number who have been released. This is, if the designation is found, yes. Very, very few. I think it's less than 20 out of the 380.
18, you're correct.
18 out of the 384 went in have never come out. And the prospects of them ever coming out, from what we can see by past pattern, is extremely limited. So if you're sitting there as the judge and you're saying, I'm in fact sending this person to life, not the life for murder, or for first or second degree or manslaughter or other serious violent crimes where there's going to be, the person's going to be out in 10, 15, 25 years max. Yeah. This person's going to stay in prison for the rest of your life. So you're sitting there as the judge and saying, this person has to tell me why I'm not going to keep him in jail for the rest of his life. Don't you agree with me that the vast majority of judges in this country, certainly at the upper levels of our superior courts, are going to say that's offensive to the Charter and are going to strike this provision down?
I couldn't disagree with you more, Mr. Camarton. I don't believe that that's the case, and I indicated to you that the Supreme Court of Canada indicated that the presumption of innocence, as articulated in the Canadian Charter of Rights and Freedoms, applies to individuals who have not been convicted, that once having been convicted, you don't get that presumption. And in the cases that you indicated, you quoted the statistics correctly, but again, I asked the question, how many individuals escaped and didn't get that dangerous offenders who should have had a dangerous offenders, but by reason of the challenges that Mr. Hoover indicated to you, and the developing procedures that criminal defense lawyers are developing in terms of having their client avoid that designation when in fact they should get the designation. And so whether a judge who has the ultimate jurisdiction, the ultimate discretion to give a lesser sentence than a dangerous offender, I believe that would be perfectly in order if that's what a judge concludes. But to say that he or she would be offended that we are asking that individual who's been convicted of 3 serious violent sexual offenses from showing why they shouldn't get a particular sentence, I disagree with you that would be a problem.
Now we'll go to Mr. Norlack, please.
Thank you for appearing, Mr. Minister and Mr. Hoover. We've had similar legislation, dangerous or habitual offender legislation, since about 1947. Recidivism has always been a condition, and in addition, we find that we found over time that because there were significant numbers in our society who were committing, at least in the past, who were committing offences in excess, with punishments in excess of 2 years, that they were included in dangerous offenders. And we notice in this legislation we've actually narrowed the scope, yes, as it were, and since 1997, of course, we've significantly changed the legislation to preclude those offences. But of late, and we were discussing, I know one of my confreres were discussing the actual historical changes, or we're referring to some numbers, and just at least looking over some of the research that the researchers were so kind to present to the panel, we noticed that we've gone from about 14 to 22, and I think some of the last numbers I'm talking about over a decade. Over a 10-year span, we went from 14, then we went to 22. Currently, the numbers I see on page 5 of the research numbers are up to 39, and today we heard that your estimate is approximately 50 people who it's anticipated might be classed. And I'm just wondering, in this category, what your analysis indicates, or why would your analysis indicate that we are going to continue on the incline? Because most of the argument against this says that, well, there should be a decline. If we're to assume that this legislation won't have an effect, then I can't see that, because historical patterns are showing us that there's an increase in people who are designated as habitual criminals. So my question is very simple: is could you go through some of the analysis you've done in order to come up with the number of about 50 persons?
Well, I might ask Mr. Hoover to talk about this, but trying to predict these things, and indeed predicting human behavior, is always a challenge. I mean, one of the significant changes that have taken place in this area is the Supreme Court of Canada decision in R.V. Johnson. And as I indicated in my opening remarks, this has presented its own set of challenges to Crown's attorney, and we are facing the situation where we have different interpretations of that particular decision. So I think this will clarify that. It will standardize the tests that are being used, and in my opinion, it will facilitate those individuals getting the designation who should get the designation. And again, it's not something I look forward to or hope that there will be lots of them. I mean, nobody wants to see this kind of behavior. It's a last resort. Let's face it. That's why there haven't been thousands of these applications. They're long, difficult, expensive, challenging. They stretch resources of the Crown Attorney's Office. So it is a last resort to try and bring some measure of control to individuals who have demonstrated that they have to be incarcerated. And again, it's the last resort. And we think that this particular piece of legislation can play a part of that role, and a reasonable one in protecting the public. But with respect to the numbers and the analysis, I'll ask Mr. Hoover if he has any comments.
Just briefly, I guess when we began consultations a number of years ago, I think we tried to listen to what the concerns were of all jurisdictions, and we heard different concerns depending upon the jurisdiction. Ontario, British Columbia, Alberta typically have a very high rate of applications relative to other jurisdictions. The Northwest Territories, Yukon, none of it. Very low rate as a percentage of the number of those types of offenders in their jurisdictions. And when you ask why, you'll see different types of answers. A lot of it has to do with the resource implications. Again, as the Minister has pointed out a number of times, these are extremely resource intensive. They often last 1 to 2 years or longer, plus they're often appealed. So a jurisdiction without the resources to manage this will, in many cases, be scared off these. So we think that there will be, because of the combination of the Crown Declaration and the reverse onus, there will in fact be a bump in the number of applications, especially in these traditionally non-participatory jurisdictions. As well, you are going to see, even in places like Ontario and BC, probably a more aggressive approach when an individual is before the Crown that typically might fit the pattern. They'll be more inclined right from the beginning, I think, to seek the psychiatric assessment, which, again, very expensive process. The resources are very stretched, and even in the more resource-rich provinces. And until you get that assessment back, you can't be sure whether or not this guy is manageable in the community, and so you're taking a bit of a risk. So I think a big part of this legislation is to take that first step and figure out whether or not the individual merits further consideration.
Thank you.
Very short, Mr. Norton.
Yes, I know. We also noticed in the legislation peace bonds being increased from 12 to 24 months. Is this as a result of consultations with Crown prosecutors and other attorneys general?
This, in my opinion, is something, quite frankly, long overdue. I mean, everybody involved with the criminal justice system, be they on the front lines or the policy makers, if there is unanimity about any particular segment of this bill, I would guess it's in that particular area that 24 months is a more reasonable period of time to set down the conditions upon which an individual will be out in the community. And so, again, I don't anticipate any controversy on that at all.
Thank you. Thank you.
Now we'll go to the second round, and it's 5 minutes round, and I understand Mr. Murphy will share his time with Mr. Bélanger. Mr. Murphy, please.
Thank you, Mr. Chair. Thank you, Mr. Minister, Mr. Hoover. We are getting into the world of reported designations and the nomenclature of applications. And if the information of the number of applications is available, it wasn't sort of canvassed in the material we had, and we would certainly appreciate getting whatever information you can give us with respect to the numbers of applications over the various years and by various provinces. I can say that in New Brunswick, talking to many prosecutors in the province, that I think the current average is 1 to 2 per year. So it's not, it doesn't sound like it's a big issue, but of course it is, because prosecutors respect the process, use the process judiciously, if I could use that word, and are looking for some improvements, of course. So the resource issue is a big issue. My question, let me just start by saying that totally in support of tweaking the dangerous offenders system, which has worked pretty well, but has some tweaking to be done to it. And I think, in contradistinction to many of the other justice bills presented thus far, this is really targeting the dangerous offender community are a community that should be locked away. These are recidivists. These are people over, on average, 40 years of age who have committed, in some cases, a quarter of them have committed 15 or more offenses, and they're dangerous and bad. I won't say bad people, it's too moralistic, but they're dangerous to society. So we want to support you in making this bill better, Mr. Minister, but I do think, you can nod and make a face if you wish, but it's very sincere. I do think you glossed over, Mr. Minister, the charter aspects. Wanting this to work means that you, I think, should have canvassed Section 7 as it relates to liberty, and the Supreme Court of Canada cases that in respect of the necessity to show in aggravating circumstances on sentencing that those aggravating circumstances be proven beyond a reasonable doubt. In that, DOs are going to lose their liberty, which is the fundamental aspect of Section 7 of the Charter. Are you not concerned that that standard must apply to an aggravating circumstances, which in this case is the triggers, if you will, of your bill?
Thank you, Mr. Chairman, Minister, Mr. Hoover. I'd like to know exactly what your title is so that we could see where you are within the Department of Justice. Now, Minister, I think this committee's work will certainly go on into the fall. Certainly for the people that are new to this type of study, we will have time to do a thorough reading of this over the summer. I'm wondering whether you'd be prepared to share with the committee the documentation the supporting documentation for this bill, statistics or estimates based on the number, the categories, etc., whether you have this type of information. I imagine you've asked for some studies to be carried out in order to arrive at this bill. Would it be possible to have an inventory, if you will, of the studies that were commissioned by the department or which the department used? Earlier on, Minister, you said that you had received a legal notice as to the constitutionality of certain provisions in this bill. Would you be prepared to share this with the committee? And finally, I'd like to know, because there will be an effect on the resources that will be needed in terms of the shifting of the burden of proof or the onus of proof towards those who have been found guilty, is there something within the appropriations, would there be an increase in resources to make sure that those who have to carry the burden, if this bill were to be passed, that these people would have the necessary resources to carry out their duties?
Thank you very much, Mr. Chairman. I'm not quite sure, Mr. Murphy, what you mean by tweaking the bill. You know, if it seems to me that if you're pursuing the route that on the previous questioner from your party about introducing amendments with respect to breaches by long-term offenders, that would be a major change to the bill, in my opinion. And you heard my opinion to Madam Jennings that we should leave that issue for another day. If there are minor amendments that improve the bill, and again, I think the bill, I'm always open to suggestions and on this or indeed any other bill. With respect to your comments that whether this will meet a challenge under the Charter, these are always considerations when we put this we put legislation before Parliament. Indeed, that's one of the specific items that the Attorney General has to direct his or her mind to before tabling legislation. And the analysis that we at the Department of Justice have undertaken with respect to this legislation indicates that this is constitutional and that will withstand a challenge if and when that takes place. I'm going to ask Mr. Hoover to have any further comments with respect to statistics. We are prepared to provide any statistics that we have on this. I think we have given them a number. I'll have Mr. Hoover have a look at that. With respect to a note that I have reviewed, I don't think I'm not sure I've said a specific note. My analysis and my discussion with the Department of Justice with respect to the bill, that it is constitutional, and of course that they, Mr. Hoover among others, directs their attention. You hadn't indicated what exactly is his role. He describes himself as a counsel within the Department of Justice, and as I indicated in my opening remarks, that he has had a particular connection with this particular piece of legislation. In terms of the costs of an individual, the best estimate of detaining an individual for 1 year is about $87,000. They would be within the federal penitentiary system, of course, and the resources we believe are there to handle any increase of individuals. As others on this committee will know, when people ask me what is the cost, I always tell them there is a tremendous cost that society pays when some of these individuals don't get the sentence that they should get, and the havoc and the cost that they have cost society up to this point. But I think you're anxious to either give me a supplementary or more clarification. So I will.
Was not a question Mr. Bélanger asked you. I'm just going to ask him to repeat the question, and you can give us a written answer, please, on this one. Yeah, Mr. Bélanger.
Thank you, Mr. Je vais le dire en anglais pour s'assurer que le ministre comprenne.
I'll say it in English.
You're quoting, you said you'd received advice. So I was wondering if that advice, presumably in a written form, if you would be prepared to share. And I also referred to an inventory of studies that the department might have had conducted for itself or referred to. And finally, when I spoke of resources, I meant not resources for people incarcerated. I meant in terms of if we reverse the onus onto those found guilty for the third time, have any provisions been thought of for resources for those who now have to make the proof that they may or may not be dangerous offenders?
With respect,
answer because time flies. I would like to have on these three questions from Mr. Bélanger.
Any advice that I receive, Mr. Bélanger, would be protected by solicitor-client privilege. With respect to the resources, I'll ask Mr. Hoover to make comments on that.
I think in the first place, the vast majority of dangerous application defense is actually conducted under provincial legal aid programs with some federal funding. So the impact of resources of these changes would actually be borne almost a very large majority by the provinces themselves, who primarily support the ability to, as best we can, to provide these changes, these reforms to the dangerous offender provisions. The actual impact, again, will depend upon the numbers of applications brought. There's nothing being done here to fetter the Crown discretion as to whether or not to bring a Crown application. So ultimately, it will be the Attorney General of each province who has to approve a dangerous offender application to determine what the impact is going to be on their resource base. I think that answers that part.
Thank you. Now we'll go to Mr. Moore, please.
Thank you, Mr. Chair, and thank you, Mr. Hoover and Mr. Minister, for being here today. Sometimes what gets lost in all this as we discuss the details of a bill is, what exactly are we talking about? And I'm wondering if you could comment a bit on who is a dangerous offender. What are some? It's a relatively small number of Canadians. There's over 30 million Canadians, and yet we have these very few people that are designated. I'd like to maybe a snapshot of what type of person, what type of traits these people have shown with regard to maybe with regard to the justice system and with regard to their fellow Canadians.
That's one of the reasons why a psychiatric assessment is done in these matters, is to get a better insight into that individual. But I think it suffices to say this bill is particularly directed at those individuals who have shown a repeated pattern of violence, sexual violence against individuals for which they have received considerable penitentiary terms, or the individuals who received 2 or more years in the past. Over a number of occasions, they've been convicted. It's not a question that we get the right person or the wrong person. We've got the right person here because they've now been convicted on 3 separate occasions. So these are the worst individuals, the most dangerous individuals, and these are the ones that I think Canadians, for the most part, are most concerned about, and Canadians want to see them dealt with in a manner that's consistent with their respect for the rule of law and their respect for the criminal justice system, and that and to not take the steps that I believe a bill like this takes has the opposite effect on people's confidence in the justice system. But again, in terms of the profile of that individual, I think Mr. Hoover indicated that, or perhaps it was Mr. Menard, I forget, but they're usually, by this time, they're in their 40s usually. I mean, we're not, it's usually not somebody who is in their early 20s. These are people who have shown a consistent pattern of unsocial behavior that results in violence and pain and suffering for those around them. So that's who it's directed at. Did you have any comments on that?
I believe you will be hearing from Mr. Jim Bonta of the Correctional Directorate at Public Safety Canada, who has a great deal of expertise in this area and is much better able to answer those types of questions than I. Although I would add that I think Correctional Services of Canada are perhaps noted around the world as one of the leading agencies, not just to keep high-risk sexual and violent offenders in prison, but to attempt to analyze and understand what makes them tick in the first place and what type of programs can help treat and cure the propensity for violent sexual behavior. So essentially, we rest much of our analysis for dangerous offender proceedings on the expertise coming out of that, which again, world leaders. And what we're looking for, what the judges are now looking for in those psychiatric assessments, in fact, are indications that the individual is simply unable to respond to the treatment that state-of-the-art facilities and psychiatric caregivers are providing to these individuals. And by failure to respond, they show a propensity that regardless of how much resources you pour into them, they are going to reoffend violently and sexually. And again, I think Mr. Bonta will be able to provide a lot of detail on that process.
Now we'll finish with Madame Freeman. S'il vous plaît.
Bonjour, Monsieur Nicholson.
Welcome, Minister Nicholson. Thank you for being here today. I have 2 or 3 small questions. With respect to the primary designated offenses, in the spirit of this bill, would these primary designated offenses, say an offender commits a common offense, attempted murder, sexual assaults, would these, for instance, these 3, say, primary designated offenses at the same time lead a person to be a designated dangerous offender? Is that how it's would be designed? From what we understand today, you could have offended in 1990, in 2000, and 2007, so at this point would be the 3rd time the person has committed a primary designated offense, so there would be a reversal. And if the person commits 3 of these offenses at the same time, during the same incident, how do you proceed, or how would we proceed under this bill?
I suppose there's a there's a fine line sometimes, but generally when the actresses are connected to each other for one reason, you break and enter, you'll steal something, you might commit a sexual assault, and there might be a robbery. There might be a number of primary designated offenses in those actresses, but if they're all connected, that would only be able to, for example, count as one of the offenses, assuming that he got in totality 2 years. Whereas you can be convicted today for a bunch of different offenses that you did historically, one in 1978, one in 1982, 1985. Those would most likely be interpreted as 3 primary designated offenses because the actresses were not connected in time there's no nexus. So based on current jurisprudence, in that scenario, the latter would in fact have 3 primary designated offenses qualifying for the presumption and the former would not.
All right. And under this bill, what would happen to the offender who's committed 3 offenses before the entering into force of this bill?
Still be brought, as Mr. Carmartin was indicated, on the first offense, the Crown Attorney could make an application for a designated offense. The change that this brings in is that we have 3 of those convictions under the circumstances Mr. Hoover enumerated, that on an application, and again, it's still discretionary by the Crown Attorney. The Crown doesn't have to go forward with that. But if they do go ahead with that, then there would be a reversal of the onus. The onus would then shift to the individual who has been convicted for the 3rd time.
That's not quite what I was pointing to. I was trying to understand the offenses that are committed before the entering into force of this bill. If this bill were to be passed, those that would have been committed beforehand, will they be treated as offenses?
I think given, again, current jurisprudence regarding the issue of retrospective application of current law, if an individual was, for example, charged prior to coming into force of this legislation, it probably would not apply, these provisions. But if a person who committed the act, say in 1978, but was charged after coming into force, we believe that a court would find that these provisions are consistent with prior jurisprudence. So yes, they would apply for those types of individuals. Yeah.
You're going to take that into consideration.
After coming into force, I don't think there would be any question. There might be some question if the trial started before coming into force, but he wasn't sentenced till after coming into force. So there might be a gap, and that'll be for the courts to decide.
I just want, before closing, I know Mr. Carmartin wants to ask a point of clarification to the Minister. Mr. Carmartin, please.
Minister, I think you left an impression here that's not accurate. I'm not suggesting you did this intentionally, but you indicated in response to a question from me that there are about 50 cases a year that would get caught by the reverse onus. My calculation is it's as little as 4 or 5. There's 2 types of designations. There's a dangerous offender, there's the long-term offender. In total at this point, those are running at, well, according to the stats we have, about 53 a year. 14 dangerous offenders, 39 long-term offenders. Of the dangerous offender designations, my assessment of it, only 4 or 5 of those will fit into the category where it will be the 3rd offense, serious criminal violent offense. Do you agree with that assessment? Because you've left the impression there's going to be 50 that this is going to apply to. In my sense, this is only 4 or 5 per year.
Mr. Hoover.
We actually do have some data we can provide. It's a little bit rough because we're looking at the number of offenders who committed one of the primary designated, and then is there another one, is there another one? It's sometimes a little bit difficult because they can show up more than once. But we think that certainly the analysis we did, and we can provide the numbers that our research department did, it looks like varies from year to year, but 30 to 50 individuals actually are convicted of a 3rd offense that actually did receive a jail sentence of 2 years or more. So I can undertake to provide that to you.
Yeah. That's up. That's it. Okay. If you have any other thing, thank you very much, Mr. Minister. I really feel that your presence will help the members to take the analysis and a decision concerning this bill. We're going to suspend for a few minutes for our next set of witnesses.